are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. I'm very relieved that everybody could join us today, at least remotely. We will hear argument now in number 251306, Mark Lee versus West Virginia University Medical Corporation. And Ms. Jones, when you're ready.
May it please the court. Thank you, Your Honors, for the opportunity to present this morning and for pivoting to a remote session. Mr. Harrison, good morning. I would like to reserve, if I can, 3 minutes for rebuttal. Your Honors, I'm proud to represent Dr. Mark Lee and respectfully request that this honorable court vacate the decision of the trial court and remand to permit Dr. Lee to present his claims to a jury. Dr. Lee's an impressive and highly regarded neurosurgeon. He's had a very successful career, and this hiccup, I will say, at the WVU UHA entity has been something that he's had to overcome. By way of brief background, he has a medical and doctoral degree from the University of Chicago Pritzker School. He has residency and pediatric neurosurgery fellowship training at NYU, an epilepsy surgery fellowship at the Medical College of Georgia. He served 4 years of active duty as a major in the U.S. Army. He spent 10 years on the faculty at the Medical College of Georgia, chaired the Department of Neurosurgery there. He was then a CEO of a private practice group and later obtained an MBA as well. This is an impressive intellectual and academic neurosurgeon. He was recruited significantly by WVU to come to West Virginia and turn around what was a struggling department of neurosurgery. And he thought it was going to be a great fit. And he enjoyed the work initially. Unfortunately, UHA, University Health Associates, the entity that has partnered with and jointly employed Dr. Lee, has perhaps created a misimpression of him, which is why I wanted to provide some background.
I'm sorry, I 100% understand your client's impressive credentials. But just when you mentioned UHA being a joint employer, I do have just sort of a question about the posture of this case. I know that your position is that UHA and WVU are joint employers. The district court didn't decide that, didn't even assume that. Although he did make the district court judge made two sort of narrower assumptions. But I am still struggling to figure out how, if we are not assuming away the joint or integrated employment question, then in a suit against UHA, it even matters why Dr. Lee was removed from his position as chair over at WVU. Do you understand my question?
I think so, Your Honor.
Okay,
and I'll attempt to answer it, but you can let me know if you need more. First of all, the two entities work together to employ physicians who serve as faculty members, but also serve the hospital system. And so each employee of Dr. Lee, like other physician employees, are employed by both entities. In fact, in the pleadings, that was admitted as a joint employment scenario.
I do understand your argument on that point, but I guess I'm just sort of struggling with what happened in the district court, because the district court did not assume that that was correct for purposes of its decision, but it nevertheless kind of reached the merits of why Dr. Lee was terminated over at WVU. And I understand why that matters if you think they are joint or integrated employers, but I'm struggling with why it matters if you don't think that. And the district court was not prepared to say, I'm assuming that that is the joint employment part is correct. I will let this drop in a minute because this is just something that has confused me, and perhaps I'm not understanding the district court decision properly.
Well, Judge, there's an admission in the pleadings of joint employment from the first step. So I think that's an important issue to consider. I agree when we got to the contract claim as well, there were issues about whether that joint employment status went to the same, allowed the same terms for each entity to be considered. And the district court didn't think so. But we take the position based on that admission of joint employment and the interrelationship and the facts that demonstrate the negotiation had to involve both parties. Payment comes from both parties, substantially from UHA, but only partially from WVU.
Counsel, how does that work with WVU and sovereign immunity? I mean, is there a case where a court has allowed where a private employer to be liable? I mean, under your theory of joint employment, where his counterpart has been dismissed based on sovereign immunity?
Your Honor, I won't point to a specific case identical to that. What I can tell you is that by virtue of the status of the employment and the fact that both agreements refer to each other, that the party's intent, which when you evaluate an integrated employer scenario is a critical point, the party's intent was that both scenarios applied. That is, both entities had joint control.
Ms. Jones, let me go at it another way, because that's what's confused, I think, some folks. For not the university has sovereign immunity, but for the other party to get out, they're going to have to plead the affirmative offense of derivative sovereign immunity, and they've not done that at this point. So why does it matter? At this point, what the issue is here now is whether or not you get by summary judgment on a material issue of fact, or a discrimination as a matter of law. Is that not correct? I mean, this issue of derivative sovereign immunity, all that doesn't matter today. What matters is you get by summary judgment on the discrimination, the retaliation claim. Isn't that correct?
Well, I would agree with you, Your Honor. Yeah, Judge Floyd, I would agree with that. I would agree with you, Judge Floyd, yes.
Now, let me ask you something else. One other thing to try to put this in focus in my mind. It's a hypothetical question. It's not a trap, not a trick, but just bear me out and listen to it. You have a bar. You have a female bartender, has a male clientele. Male clientele goes to management and says, we don't want a female bartender, we want a male bartender. They fire the female bartender. In the meantime, they hire the hostess, who is a female. She becomes a bartender. They look around for a female bartender, for a male bartender, and they can't find one. And then they say to the hostess, you can have the job. Now, the question is there not still direct discrimination as to the original bartender?
I think there's a good argument that there is, Your Honor.
So is this your case?
Your Honor, it's an interesting comparison. I think you're right. I think you're right. We believe there is direct evidence here and a direct evidence claim on the discrimination. And that's something that the trial court disregarded. Our position has been that the direct evidence with respect to age discrimination was relevant to be considered, that should have been evaluated, and was not. The direct evidence information or evidence supports direct comments made to Dr. Lee by the decision maker in the context of replacing him, age-based comments made on 2 separate occasions, no denial that those statements of age-based comments were made.
Can I ask you a question? This may circle back to Judge Floyd's hypothetical at some point. But, for it to be direct evidence, the comments have to be related to the employment decision that's being challenged. And you have comments saying it would be really good to get a young person in this job because they could stay for a long time. But then they turn around and hire another 62-year-old. So it is hard for me to see, I guess you could look at it one of 2 ways. How are these comments directly related to the employment decision if the decision was to replace one 62-year-old with another 62-year-old? I guess, or even if it's direct evidence, how do you show but-for causation? He's hired when he was 59, if I'm getting this right. So it's not like they hired him when he was 30 and then thought he was too old. They hire him when he's 59. 2 years later, when he's 61, they basically start easing him out of the job. and then they replace him with someone the same age as him. I've just never quite seen a case like that where someone would say there's an inference of age discrimination here.
Here's why, Your Honor. Two main points. Number one is because in the context of making those statements, multiple statements on multiple occasions.
Two, right? Do we have more than two? Okay.
Two occasions and two statements within each event. They were made directly to Dr. Lee saying, we are going to replace you with somebody younger. So the context of telling him he's out and being removed is to put in somebody younger. Very direct about the position and about the planned decision. Then other things occur relative to age, but jumping ahead, he reports that through counsel, then a decision to remove him is actually made. So again, another direct report, decision to remove is made. The interim chair, who was his vice chair at the time, Dr. Conrad, replaces him. He replaces him from September 1st until May. There is a search committee that is created. The search committee created included Dr. Conrad as a member. If anyone has any experience in academia, any candidate interested in the position is not going to be on the search committee. So Dr. Conrad is on the search committee, is not looking to be or looking at as a candidate. So our position is his later position as permanent chair in May was effectively a sham.
But is there record? I mean, I see that argument in your appellate brief.
Yes.
I guess I have two questions. Did you present this sham argument that they fired him for age discrimination reasons, but then they hired another 62-year-old to cover their tracks? Is that argument presented in the district court, and is there record evidence that would support it, besides the fact that the person who got the job was on the search committee?
Well, Your Honor, we developed that in the same argument in the response to the summary judgment position. And we do believe that because of this sort of steps that had to be taken for the hiring of a new chair, which involved the search committee, various candidates, all either dropping out or not being of interest, and then them going back to Dr. Conrad and saying, why don't you take this position? We believe that creates an inference that may not be worthy of belief for purposes of saying it's not a direct replacement of somebody else. Our position is there's enough facts there that should be looked at, that should be looked at carefully, because it is, admittedly, they are close in age. Admittedly, Dr. Lee was hired just a few years earlier and then let go. But when there are repeated statements that can, to his face, about replacing him with somebody younger and somebody who has a longer runway and who could stay in for 10 to 15 years.
But let me ask you about that, because there's a case, I think it's Smith versus Flax, the case that talks about succession planning and how succession planning is less likely to be discriminatory. And I'm assuming that Mr. Harrison is going to probably say, this was just a conversation regarding succession planning, what's going to happen after Dr. Lee leaves the position. How is that different than the case, the Smith, I think it's versus Flax case?
Your Honor, succession planning is entirely different, respectfully, because that's something that the person involved is planning with the person who wants to install a replacement. That's an understanding between the parties.
That's exactly what happened here. At the time these comments were made, he's been offered this other position. They're working cooperatively, basically, to ease him out into this other position and replace him with someone. That's the context for the comments. When Marsh says this, everyone is under the assumption he's on his way out, and they just need to figure out what happens next.
Well, except that Dr. Lee wasn't under that assumption when it first came up.
But what matters, right, is what Dr. Marsh was saying, not what okay.
Well, respectfully, Your Honor, Dr. Marsh was saying that here's an opportunity, and can we work out for you to come into this new opportunity? To say that he is not at the same time saying to Dr. Lee, if it doesn't work, Dr. Lee said to him, if it doesn't work, I want to stay on his chair. And there is record evidence with everybody that he was then staying on his chair. He told Dr. Rezai that. Dr. Rezai understood it. Dr. Marsh admitted he understood that he was still staying on his chair when he said that this wasn't going to work out for him in terms of the proposed position that they came up with, and that he would stay on for a period of time. And so I understand the numbers went red, so
No,
I'll
no,
just
please,
ask.
no, as long as we're asking you questions, you should feel free to answer. I do just have one question about this. I guess I understand what you're saying, and this is a complicated factual record. Is there a case you can point me to where, sort of roughly like this, someone is fired 2 years after they're hired, or they start to fire him 2 years after, terminated fully 3 years after, by the same person who hired them, replaced with someone the same age, and that case goes to a jury on age discrimination? What is the closest case for you that would just sort of suggest that even though this looks kind of like it was anything but age discrimination, we can get past that and send this to a jury?
Well, Judge, there was the Sempovich case.
Okay.
Now, I appreciate it, it was a 21 case. The Sempovich case talked about the employer not being genuine in its position. The same actor inference was erased. It wasn't an age case, though, Your Honor. It was a sex-based Title VII claim. But there were arguments that the employer was not being genuine in what they were saying.
Okay.
And I think there are a lot of facts in our case that reflect our position that the employer is not being genuine in what they're saying, that they have come up with a lot of information post age comments, post reporting of age discrimination, when there was a belief that things were still on status quo. Perhaps there had been this proposal. Dr. Lee didn't love the proposal, but he was remaining as chair. He had already reported age discrimination through counsel. Then I reported age discrimination, and only then, within 2 weeks, was he told, "You're out, and you're out now." Again, another sort of academic area.
I should
Don't
probably
lose
now
someone.
just ask if either of my colleagues has questions. Judge Floyd?
I think, when you come back on your rebuttal, I want you to talk about the retaliation claim a little more.
Okay, thank you, Your Honors. Thank you.
All right. Mr. Harrison?
Thank you, Your Honor. Good morning. My name is Justin Harrison, and I'm obviously appearing today on behalf of West Virginia University Medical Corporation, otherwise referred to as University Health Associates, or UHA. Obviously, we feel that the district court's summary judgment decision should be affirmed, and there are three principal reasons for that. First, there's no evidence that Dr. Lee's age was the motivating factor for removing him as chair. And that's dispositive of the age discrimination claim, regardless of whether we're evaluating it through the lens of direct evidence or through indirect evidence. Second, the purported activity that Dr. Lee engaged in took place after the principals decided that Dr. Lee should be removed as chair. That discussion was broached in March or April of 21. The alleged comments that Dr. Marsh made took place in May and June of 21. The decision to remove Dr. Lee as chair took place July 22nd of 21. We don't have protected activity until 7 days later, when the letter from Ms. Jones is sent out, complaining about age discrimination.
As to that assertion about what the timeline was, what evidence, if any, do you have in writing or anything that supports those dates? Because you got the attorney letter of 7/29/21, and then you got a follow-up of 8/12, and then on 8/29, it looks like you made the decision to terminate him, and your letter says, in light of your recent letter, we terminate you. So the only evidence in the record about timelines are the plaintiff's attorney's records. Where do you get that this decision was made in March
Well, we have testimony from all the principals that established this timeline that I just mentioned. First of all, we have Dr. Lee admitting that the discussion about him transitioning into a new role took place at his annual review. The annual review took place in March of 21.
That's true. That's true as far as talking about an annual review, but no decision was made to terminate him in March. You began an academic discussion, it looks like to me.
That's correct, Your Honor. The discussion was broached at that annual review in March, but the final decision to remove Dr. Lee as chair was made by Dr. Marsh and Dr. Rizai on July 22nd, 2021. There was a final attempt to salvage the relationship between Dr. Lee and WVU Medicine. There was a meeting that took place in Dr. Marsh's office. It was a very unproductive meeting. It sounds like it was a very negative meeting.
But there was, my concern regarding this is that these conversations were all dating back to March were about transitioning him to a different position, never termination. And so it seems in the meeting as late as July 22nd, there was the conversation was about transition. And then you get the letter on the 29th, and there's and then another letter on the 12th, and then we get a letter on the 18th, and it says you're removed from the chair position regarding termination. So it kind of switches over from we're going to transition you to another department or another position to just termination. How is that? I mean, what was the motivation, I guess, for the change from transition to termination, and it's and why? And it just so happened, I guess, 7 days after that. 6 days after that last August 12th letter.
Sure. So just so the records, we're on the same page. The final decision to remove him as chair was made following the July 22nd meeting. That's when Dr. Lee walks out of Dr. Marsh's
Yeah, but there's
office.
no evidence. There's no evidence at that point. So for my purposes, I'm looking at August 18th because there's no. I mean, you haven't not provided any evidence other than your party's testimony that the decision to terminate was on July the 22nd.
Understood, Your Honor. Respectfully, that is evidence, and that testimony is unrebutted.
Well, how is it not rebutted by the letter that Dr. Floyd, that Judge Floyd drew your attention to, where they write? I just don't understand this. You say they decided to fire him on July 22nd, but they write to Dr. Lee and say that's not when they decided to fire him. They fired him after much thought about the issues raised in his August 12th letter. And
Well,
that's when
that's-
they decided to fire him. So how is that not enough to get to a jury on about when this decision was made and why?
Well, Your Honor, respectfully, those are communications coming from counsel. That's not testimony coming from Dr. Marsh or Dr. Rizai.
Okay, so your answer is the lawyers got this wrong, but that's not a jury question. The fact that the lawyer said something different from the client, there's no fact issue there. We should all just, okay.
Right, the sworn testimony is from Dr. Marsh and Dr. Rizai, but going back to
But
Judge
I guess
Benjamin.
back to my question, but there's no documentary evidence. There's nothing in writing. So you decide you're going to terminate him. We just all decide on July 22nd, we're going to terminate him. And between July the 22nd and July the 29th, there is nothing sent to Dr. Lee saying, hey, you're terminated. So is that just a conversation between Marsh and Rizai just saying, hey, we're going to terminate him, but no one takes any action to actually notify him that he's been terminated?
So I don't think this comes through in the appellate briefing, but we do have it in the record. And, those principals struggled with how to communicate. This isn't a situation where you just randomly remove somebody from a significant leadership position. There's planning involved, there's communication. And so the principals here, Dr. Marsh and Dr. Lee, were working with how to plan that out. But to your question earlier, Judge Benjamin, you asked what changed? Why did we go from transitioning him to a different role to now removing him as chair completely without the other role? And the answer to that is because Dr. Lee rejected the new position. It was floated to him as a concept during his annual review. He was receptive to it. A pro forma was put together. It was presented to him in May. And Dr. Lee testified that it was a good concept. It was actually a concept that he had discussed with Dr. Rizai in the past.
Can I
But
just ask a clarifying question? Are you saying that he turned down that director job at the meeting on July 22nd?
no, he had previously
Okay,
rejected
right.
it, Your Honor.
Okay, so what happened on July 22nd that made everybody change their mind and go from, you can stay for a year or two, we'll have a soft landing, to get out of here?
As Dr. Rizai testified, Dr. Lee kind of became uncommunicative during that meeting.
That's not what Dr. Lee says, though, so I don't understand. We can't, if we have conflicting testimony, and he
Well,
says,
that's-
all I did was say, let's leave this to the lawyers. Like, we're going around and around on this, let's leave it to the lawyers.
Actually, Your Honor, respectfully, I disagree. There's no evidence in the record challenging Dr. Rizai's description of that meeting. He referred to Dr. Lee as being recalcitrant. Dr. Marsh is trying to talk to him, and all Dr. Lee is talking about is pay me my 2 years and I'll walk away. That's Dr. Lee shutting down. He's not talking about a transition. He's not working with him on how the Department of Neurosurgery is going to look for the next year. And so that's.
Did I misread the record? He does not say that he said, let's leave this to the lawyers.
Dr. Lee did say at one point or another, talk to my attorneys.
Well, how is
supposed to
that
have-
ending negotiations? That's like, I just want to negotiate through my lawyer.
Well, as a practical matter, if you're Dr. Marsh or Dr. Rizai, you can't manage somebody's transition through an attorney. He's got to be able to talk to them about what the Department of Neurosurgery is going to look like, what his role is going to be in that process without having to go through counsel.
Mr. Harrison, all this negotiation aside, why did you fire him as dean?
Your Honor, he was removed as chair of the Department of Neurosurgery because of concerns regarding his leadership role and his acumen as an administrator. Ms. Jones mentioned earlier discussed Dr. Lee's credentials. I want to be absolutely clear about this. Nobody at UHA or WVU has ever faulted Dr. Lee's skills as a pediatric neurosurgeon. And I will submit that anybody who's board certified in neurosurgery is certainly worthy of our respect and adulation. But as an administrator, Dr. Lee had several shortcomings that became apparent a year after his tenure ended his role.
Where is the documentation of that in the record?
So you've got witness testimony from depositions.
Documentation.
Well, I think what you're referring to is whether there was a written warning or whether there was a counseling form, and those things don't exist. And frankly, that's not too surprising because it shouldn't be surprising that neurosurgeons making $1 million a year aren't going to be reviewed like other employment circumstances. But there were concerns about where the department was heading and what he needed to work on, and those were touched upon in his written evaluations. And Dr. Lee admitted that in his 2020 evaluation with Dr. Charlton, it was unpleasant. He couldn't remember specifically what was said, but he admitted he was angry, and he was so upset that Dr. Rizai actually had to go calm him down at his condo on a Sunday afternoon. So we do have record evidence that he was counseled about his performance and that the principals at WVU and UHA had concerns about that. And frankly, there's absolutely no reason in the record to challenge their concerns. He's chair of the Department of Neurosurgery. He's considered to be an absentee chair. He's not on campus enough. His individual productivity is declining. He's not attending meetings. He's actually undermining Dr. Rizai. And all of that is in the record. Those are the performance issues that led the principals to have that sit down with him during his annual review in 21 to say, hey, would you be interested in this other role? And he says, yeah. They're not asking him to sign a performance improvement plan. There's no final warning, but the law doesn't require that.
But what do you do with the statement, taking everything you said, what do you do as a matter of law with the comment that we would like to have somebody younger to have a longer runway? What do you do with that comment?
So this court recently in the Bandy case established, so what you're getting at is Dr. Lee's direct evidence theory of discrimination. And in order for a comment to serve as direct evidence of discrimination, it's got to satisfy the 4 factors that this court set forth in Bandy. And I think Judge Harris touched upon this earlier, but one of the 4 factors requires that the comment be related to the contested employment decision. And the contested employment decision here is the removal of Dr. Lee as chair. There's no reason to believe that those comments by Dr. Marsh, made in May and June of 2021, reflect upon Dr. Marsh's intention to remove Dr. Lee for his age. They talk about what he wants in his successor, and that's somebody with longer runway. And I'll tell you how that fits into the case. Both Dr. Rezai and Dr. Lee testified that his tenure in that position was never intended to be long-term. Dr. Lee was brought in to fix the program and stabilize it before it got elevated to another level. Dr. Rezai is trying to create this signature program of neurosciences at the Rockefeller Neuroscience Institute with all these different subdivisions, and it was critical for the neurosurgery department to stabilize and then elevate its profile. Dr. Lee was brought in to stabilize it. Dr. Lee admitted he didn't intend to be in that role for long. He had other aspirations, whether that was at WU Medicine or somewhere else, I think is a debatable point, but you don't have to resolve that. And Dr. Rezai testified he wasn't brought in to be a long-term fix. In contrast, you have somebody like Dr. Conrad, who replaced him, who has a phenomenal academic record in academic medicine. I mean, his resume is substantially different than Dr. Lee's, and it's about improving the profile of the department. And so when you're talking about somebody who's going to stay there and have a longer runway, Dr. Rezai is focused on somebody who's going to be in that role long-term, and Dr. Conrad's already served in that role longer than Dr. Lee has.
But the initial take of that comment, and by the way, Bandy, I mean, it clearly was a direct evidence case where the comment was that they had decided to hire somebody else who was younger and more energetic. In this case, is so we can have a longer runway. I mean, which is to me kind of synonymous. So are you saying that that comment about the longer runway doesn't count as direct evidence in this case?
Correct, Your Honor. Based upon the holding in Bandy, we do not believe it's direct evidence. But, you know.
Well, hey, hang on a second. I wrote that opinion. And I think both of you may have read it too quickly. Here's what I said. Here, Lutheran's comment directly evinces age discrimination as it was, and then going through the 4. Then I went through the 4 factors. I mean, clearly, this runway comment. I mean, what is it if it's not that we want somebody younger?
Well, Your Honor, respectfully, you can have a 70-year-old in that position with a longer runway rather than somebody who's younger or the same age. The goal is to have somebody with a longer tenure, regardless of their age. And so it's not direct evidence because it's unrelated to the decision to remove him as chair, and the undisputed evidence is that the decision to remove Dr. Lee as chair was based upon his performance on the administrative level, not as a surgeon.
Well, that goes back to my earlier comment that where is the documentation? Because you can fill in the blanks after you make a comment like we need a longer runway, and that's what concerns me a little bit about this case.
Well, as I mentioned, there is no documentation where Dr. Lee receives a final warning or written counseling, but he does receive a written evaluation in April of 21 where they talk about areas that need to be focused on. Dr. Charlton testified that those are actually areas of improvement. And that's the same thing for the evaluation that took place the year prior. And so you're right, we've got testimony, but there's no reason to doubt the testimony. So let me back up a second. At the beginning of my remarks, I mentioned that you still have to have but-for causation. In other words, there still has to be reason to believe that Dr. Lee's age was the motivating factor, not one of several, but the motivating factor. You still don't have that here. There's no evidence that it was the motivating factor. And that that addresses both the direct evidence argument and the indirect evidence argument that was advanced by Dr. Lee in his opening brief. There are other aspects of this case that I would like to touch upon, but before I turn to any of the subjects, I do want to pause to see if there are any other questions about the direct evidence argument or the but-for argument. Judge Floyd, you had mentioned earlier some interest in talking about the retaliation theory. So, and maybe this goes back to Judge Benjamin's questions on joint employer as well. Obviously, we made a sovereign immunity type argument at summary judgment. We did not renew that on appeal. I don't think this court needs to reach that. But, you know, here you've got this contract between UHA and Dr. Lee. And the contract clearly provides that UHA can make adjustments to his compensation and benefits if there's a change to his administrative role. And there was a change to his administrative role. He was no longer serving as chair. He was given an opportunity to increase his clinical productivity to maintain compensation and benefits, but that didn't happen. And so that's why the adjustment was made. It's set forth in the contract. UHA clearly had the right to do that.
Can I just ask you a question that would help me understand the district court's opinion better? So is that the theory that when the district court says, I'm going to assume, you're only suing UHA here, West Virginia University is out, but I will assume without deciding that when you were removed as chair by West Virginia University, that was an adverse action for purposes of this employment. Is what you just said why the district court made that assumption? Because once you are removed, that will have these consequences for your compensation over at UHA?
I think that's a fair read, but I think it's also important to note, Your Honor, that the joint employer, integrated employer theory that's been advanced by Dr. Lee was only advanced in the context of the age discrimination claim. It wasn't advanced in the context of the breach of contract claim. And in researching this, we haven't identified any authority under West Virginia law or in this circuit that would allow a joint employer theory to advance in the context of a breach of contract claim. So I think
I thought we were talking about the retaliation claim.
Right. And I think that's purely just the district court relying upon the contractual ability of UHA to make adjustments to the compensation.
Well, I don't want to let this immunity argument go yet. Do you agree that you did not plead derivative sovereign immunity?
Yes, Your Honor, agreed.
Okay, so we don't have to worry about that at all at this point in the case.
We have not raised that in our appellate arguments.
All right, thank you.
Okay.
Finally, with 15 seconds, I would just like to note that the constructive discharge claim also fails because of the sequence of events and the chronology, and I would just encourage the court to focus on the sequence of events. And unless the court has any further questions, I will yield the floor.
Thank you. And Ms. Jones, you have time on rebuttal. If you'll just wait 1 second so we can get the timer up. There we go.
Thank you, Your Honor. I'd like to comment on something counsel said, that you can't manage through attorneys. Yet that's exactly how Dr. Lee was told he was going to be removed as chair. He was never given any kind of written documents about you're going to be removed as chair. He was never given any written documents or information that his acumen as administrator or his leadership skills could result in his losing of his chair position. There has been nothing. It was the communication after I made contact, made the report of age discrimination, that within literally 12 days, he's removed from his position. If that's not classic retaliation, I'm not sure what is. And the ability to say that letter of counsel, or the recent letter that was received that the court pointed out, is in fact the only notice of his removal as this position of chair. And so the court has identified in its earlier questions the need that there was nothing to support information that he was failing in his position. That last review that he had was a very positive review. He got a $50,000 bonus. He got two $50,000 bonuses. He got positive written reviews. He's being offered a potential position that they call significant, and yet now they say he should be out.
Can I just ask you, so it seems like Ms. Charlton's deposition says that, look, I raised some very serious concerns with him in early 2020. including like mismanagement of funds, but mostly just administrative, managerial kinds of things, but they were serious concerns. And I don't understand the gist of that testimony, at least, to be disputed. I mean, your client isn't saying that didn't happen, is he?
What he said, and Your Honor did point out some things previously, what Dr. Lee said was that she raised to him, perhaps you're a little strong, perhaps your approach is being viewed as too aggressive, particularly with people at the higher levels. And so he did acknowledge that. This mismanagement thing was clearly never came to fruition, and that wasn't something he acknowledged that she raised to him. But he did acknowledge it was more of a style.
Okay, so it's not disputed in this case that there were concerns about his performance going back to 2020.
I wouldn't say concerns about performance, but I think some personality conversations that had occurred. But they weren't significant. And he had the belief that he was doing very well when he was let go and didn't know about the faculty meeting that was occurring. And they told all the faculty members, oh, Dr. Lee decided to move on. First of all, so that's not even true, which is another reason why their position is not worthy of belief. That others in the department, his people that worked under him, the attendings, they were very enamored of him, thought he did a great job. And so there is evidence to support a very positive performance. And I think
I'm just going to ask if either of my colleagues has questions.
No questions.
All right, then I think we are,
well, thank you.
I'll give you just a second to wrap up.
Yeah, thank you for that opportunity, and appreciate the court evaluating all of these fact questions, because we do believe in each of the claims there are many that would dictate allowing a jury to have the case back. Thank you.
Well, thank you both very much. I am sorry we will not be able to do our usual custom of coming down to meet you in person, but we appreciate your help today, and I hope that we will have a chance to greet you in person soon.
Thank you.
Thank you.
all.
Have a good
Thank you
week.
all. Appreciate it.
Just giving a second to make sure everything is.
Yeah,
There we go.
there she is.
All right, then if everybody is ready, we will hear our next case, which is number 232019, Robert Whitaker III versus Howard County, Maryland. And Mr. Shaw, when you're ready.
May it please the court, good morning. Good morning, Ms. Purdy. My name is Adam Shaw. I represent Robert Whitaker in this case, and I would like to reserve 5 minutes of my time for rebuttal. This case is before the court for one reason, and that is because the district court resolved factual disputes that must be resolved by the jury in an employment discrimination case. At summary judgment, the court weighed the facts, weighed the evidence, made credibility determinations, and even drew inferences against Mr. Whitaker on issues regarding his performance, regarding whether Howard County's legitimate expectations were in fact legitimate or genuine, and regarding whether Howard County treated similarly situated or younger employees more favorably. Under Tolan and under this court's precedents in Sempowich and in Haynes, that is reversible error, and we therefore ask that this court reverse the lower court's decision and remand the case for a jury trial.
Can I ask you just almost like big picture and maybe even colloquially, sort of what is your theory of what happened here? I mean, there is a lot of documentation in this record of performance concerns. It's not just Captain Welsh, there's a number of instructors documenting some concerns. So is the theory that they are all biased against Mr. Whitaker because of his age? Are they just mistaken about whether he is performing adequately? Like, what happened here in your view? What is the story you would tell?
Judge Harris, there were allegations of direct discrimination in the complaint, and there are allegations and a theory that there is an age-based animus, a culture of age-based animus.
Okay, so it's in the culture. It permeates the culture is the problem here.
That is correct, and there is some discussion in the briefs about whether that issue was raised in the lower court. I'm not sure if the term corporate culture was used in the lower court, but there certainly were allegations that there were negative biases towards older employees within the department itself.
So the theory, I really am just genuine, so the theory is all of the people who are finding these performance concerns, whether they knew it or not, that was sort of an age-based assessment. It's not, the theory is not that Welch wanted him fired because he doesn't believe in older firefighters, and then everyone went back and papered the record. That's not your theory. Your kind of working theory is they were all discriminating based on age.
That is correct, Judge Harris. In fact, there is evidence in the record that was discussed by the lower court that sort of lends to the credibility of that argument. For example, if you look at the joint appendix in pages 1028 through 38, there's this Facebook post, which I'm sure the court has seen in the briefs, that was posted by one of the senior leaders of Howard County Fire Department about a year later regarding the acceptance and training of an employee of a firefighter age 51 in a different state. And
But you would agree that, I mean, that wasn't related to Mr. Whitaker. I mean, the post they had was remote and not related to Whitaker.
Judge Benjamin, I don't know if I would agree that it's remote and unrelated. I would certainly agree that it is not directly related to Mr. Harris himself. It related to a firefighter in a different jurisdiction, but I would say that a reasonable jury could most certainly look at that piece of evidence and say, here's one of the senior leaders within the Howard County Fire and Rescue Service, approximately 1 year after Mr. Whitaker's termination, saying out loud and unequivocally that he does not believe people who are essentially in the same age group as Mr. Whitaker should ever be firefighters. There's also evidence in the record that another one of the instructors at Howard County Fire and Rescue Services directly referred to Mr. Whitaker during training as the old guy, telling him you don't do half bad for an old guy. So the idea is, yes, that there is this general animus towards older firefighters, and the record bears that out. So if we look, for example, at the county's expectations, or what it proffered as its legitimate expectations of how it treated firefighters. Well, the county said, in terminating Mr. Whitaker, we terminated him because of failure to perform certain tasks under stress. So take a big picture view for just a moment. Mr. Whitaker was selected from a pool of about 1,800 applicants for about 20 positions in Training Unit 30. He started that in January of 2018. Months go by and he's progressing through training, just like all of the other trainees, all of whom were under age 40, not in the protected class. So he's certified, for example, in ice rescue operations. He's certified as an EMT. He's certified as an emergency vehicle operator. They're certifying him. And then later they come and say he doesn't perform well under stressful circumstances. Why then did Howard County continue to certify him at each stage of the training, all the way up to firefighter 1 about 3 weeks before he was terminated, and then firefighter 2, which is sort of the pinnacle, at least of the physical, the more demanding part of training, 3 days prior to terminating him? That is classic shifting of the goalpost, and it smacks of pretext when throughout the training, this is just like happened in Simpowich and in Haynes and in Lovelace, all cases where this court ruled in favor of the employee, where the employer says, you're not meeting our legitimate expectations. After the fact, they give this post hoc rationalization, but all throughout the training, they're saying, here's your next certification, you're meeting training. They gave him 2 student counseling forms. They're in the record, you can see them in the record. They're at pages 1144 and 1187 in the record. Those were 2 skills-based counseling forms, okay? And so the county...
Mr. Shaw, let me ask you how you characterize these certifications. Are they minimum requirements, or are they greater than that? And here's my concern. I guess we want to know if there's any evidence that younger recruits achieve the same certificates, but were either terminated or asked to resign. I don't know whether the record contains that or not, but first, what are these certificates? Are they just minimum requirements, or are they something more than that?
Well, Your Honor, this is a great example of a factual dispute that exists in the record, because the county certainly seems to assert that they are bare minimum requirements, but the record also bears out that every other trainee not in the protected class who obtained those certifications is now a firefighter with Howard County. I mean, this can be, I think, can be compared to like military type training, where you go through training. If you pass each stage of training, there's a graduation date. If you reach
Let me use your military example just a little further. Let's take the recruit that goes in and meets all these objective requirements and certificates like marksman, etc. Then they're placed into a combat situation and they freeze. Can that kind of conduct be the freezing or the hesitation or whatever be considered in an employment case like this? I mean, there was a hook and ladder incident that he either froze or I don't know exactly what happened, but can that be considered, that subjective stuff?
Judge Floyd, those can certainly be considered at that time. So to just carry your hypothetical one step further, I think that would make sense if, for example, Mr. Whitaker had been permitted to complete the training, had become a firefighter, and then a year later, in a live fire scenario, demonstrated some difficulty with performing under stress. But that's not what happened here. I would also mention, in reference to your question, Judge Floyd, that the record shows that other younger trainees, so for example, if you look at trainee Avery, who is now a firefighter with Howard County, in the record at pages 811 and 8 to 812, he discussed in his deposition under oath that he too had difficulties with ladders. The county has, and this came up in depositions and is noted in the record, that the county has a process for providing feedback on these types of deficiencies. So if we look at the two feedback forms that are student counseling forms that Mr. Whitaker received, the first was on April 16th of 2018. He had an issue with the ladders. Or I think in that case, actually, he had an issue with a mace. So he had an issue, he received additional training, then he objectively passed the maze, then he achieved the certification, and then he was moved on to the next block of training. At that point, whatever performance issue rose in connection with the maze or the ladder or whatever these other issues were are moot and irrelevant. And most certainly, a jury could definitely look at that and say, okay, he had a problem with mazes and ladders, so forth. There was also testimony that all of the trainees had those kinds of problems. But the jury can certainly look at that and say, how does it make sense from a factual standpoint that Howard County is going to tell its trainees, we have a process for offering you additional training and getting you up to speed if you have a deficiency, then we're going to certify you and advance you to the next round of training, but then 3 days after we certify you at level firefighter 2, we can still come back and say, oh, but all of those mistakes that you made before pre-certifications are still counting against you today, and therefore we're terminating you. That is
I'm sorry, I didn't mean to cut you off, but so it does seem, and I think this is what we've been talking around, that there is this question that Judge Floyd raised, so the county's answer is, well, those are just minimum qualifications. Like, that doesn't mean you are ready to be a firefighter. And I couldn't find anything in the record about whether, like, this happens, occasionally, all the time, that people pass firefighter level 2 and are then told, notwithstanding that, you actually don't meet our performance requirements. Yes, you have been certified at every level, you just passed level 2, but all that is minimum requirements, and you have not satisfied the additional requirements. Is there anything in the record that says whether this is a thing that happens regularly, a thing that has happened at least a few times before, or this is the first time it's ever happened?
Judge Harris, I don't think there's anything in the record regarding the frequency with which firefighter trainees are terminated after, like, firefighter 2 specifically, for example.
For failing to meet performance standards. Right.
Correct. What is in the record, however, is evidence that other trainees receive these student counseling forms. So just kind of tying this back to Judge Floyd's question, there's this process by which the counseling and feedback is given. The county actually has two sort of avenues. It has the student counseling forms, and it has a demerit system. Now, there's evidence that Mr. Whitaker never received a single demerit throughout the course of his training, And the county asserts that that's because they don't use that system. But the system that they do use is the student counseling system, and there's evidence in the record that other firefighter trainees received student counseling and had issues through training, and either were treated more favorably or continued to advance through training. So a couple glaring examples of that, particularly with regard to the claim that Mr. Whitaker was insubordinate. There's evidence in the record that another firefighter who is with the county today, Mr. Rower, this is in the joint appendix at page 793 to 794, was actually, unlike Mr. Whitaker, given formal counseling for insubordination. If we look at the counseling that Mr. Whitaker was given, he received 2 forms and both were skills-based. So the county can give you a student counseling for example, for skills, for attendance, for behavior, for tardiness. If we look at the 2 times Mr. Whitaker received formal counseling, they were skills-based. Then we look at another younger firefighter, Mr. Rower, who was expressly written up for insubordination. There was another instance in deposition testimony in the record where that same firefighter mistreated a fellow trainee to the point that he made her cry when she was in a leadership role in the class in front of the instructors. That younger firefighter is still a firefighter with Howard County today. The jury can look at that and say, Howard County treated the younger firefighter one way and the older firefighter, Mr. Whitaker, a different way. That is plainly within the realm of McDonnell Douglas Part 3, which requires that which permits the plaintiff to show that the reasons offered as legitimate reasons for terminating the employment or adverse action was a pretext for discrimination.
Well, Mr. Shaw, on your prima facie case, I think you've got a good showing, but the Fourth Circuit law under the McDonnell-Douglas test, when you switch over to the employer responding, it's pretty tough on you, isn't it?
Well, Your Honor, I don't know that I would frame it as pretty tough. I understand what you're saying. There is the whole point is, of course, to shift the burden. That's what McDonnell Douglas does. But nevertheless, under Tolan and under Anderson versus Liberty Lobby and this court's precedent on summary judgment, the district court is still required to draw inferences in favor of the non-moving party. So yes, the plaintiff does have to introduce enough factual evidence to demonstrate a genuine dispute of material fact, even at Part 2 and Part 3 of the McDonnell-Douglas test. But on this record, there's plenty of evidence that a jury could look at to say there's disparate treatment here. Mr. Whitaker progressed through training month after month, did not receive formal counseling on the issues that were later identified as reasons for his termination, and therefore this court should find that the district court overstepped its bounds and let the case be remanded for trial by jury. And I see my time is out.
Thank you. All right, Ms. Purdy, we'll hear from you now.
Good morning, Your Honors and Mr. Shaw. May it please the court. My name is Erin Purdy, and I represent the appellee in this matter, Howard County, Maryland. The District Court for the District of Maryland properly granted summary judgment for Howard County, Maryland in this case, and today the county is respectfully asking this court to affirm that decision. You're asking the court to affirm this decision because the District Court correctly held that appellant failed to present sufficient evidence to generate a genuine dispute of material fact that his termination was based on anything but poor performance. As this court stated in Henson, an employer is entitled to summary judgment if the employee fails to establish a prima facie case of discrimination or fails to raise a factual dispute regarding the employer's proffered reasons for the alleged discriminatory act. Here, Mr. Whitaker was not meeting the legitimate expectations of the department.
How do we, in terms of how does the court to handle these course certifications, the firefighter 1, the firefighter 2, and I guess my more direct question is, so he gets, say, on May the 18th, there's this counseling report regarding the evolution mazes, the ladder operations, and his breathing equipment. And then Sanchez recommends dismissing him on May the 18th. in a memo to the deputy chief, and notes that he's performing at a minimal level academically, and that he's not able to embody the principle to which the department holds is his prospective academy class graduates. And then they give him notice of this, and then on May the 21st, he receives a certificate of completion for firefighter 2. That is a little contradictory for him to, and on the 18th, there's these concerns, we're gonna dismiss Whitaker because he's not performing at the level that he needs to perform, and then on May 21st, he comes back and gets a certificate of completion from as a firefighter 2. How are we to handle the conflict in those dates? Is that not an issue of fact for the jury to decide?
I think that if the court looks at the record as a whole, that there is contemporaneous documentation that Mr. Whitaker was continuing to struggle with certain issues, and that passing firefighter 1 and passing firefighter 2 show that he was able to do these discrete tasks. All of the objective measures that he had to pass are not in the record, but there is an example of one of the firefighter 1 practicals he had to pass and it shows that they were very discrete tasks: setting up the ladder properly, making sure that he can climb. And he did not have to do it in such a manner where some of these struggles would have prevented him from passing. But then you can see that he continues to have these issues, which are documented by the instructors. For example, in the mazes, while he struggles in the first maze and ends up passing on the second attempt, when he goes into that live practical, he's still exhibiting that same disorientation that you would see in the maze. The maze is just a skill in the academy to try to assess a firefighter's ability to then go into a structure, not become disoriented, find a fire, and extinguish it.
Is there like a firefighter 3 that actually measures the department's performance requirements? Just as a matter of common sense, why do you have a system where you certify trainees as satisfactorily performing in these key training classes if they're not? What is the point of a system like that?
I think the system, there were 9 or 10 weeks left of the academy. So while I don't know that there was a firefighter 3, I don't think there is actually.
I don't think there is either. Like he's maxed out. He's good to go. Why do you have a system? And I guess the real question is there something in the record that would show why you have a system where you certify trainees as having satisfactorily performed if they're not meeting performance expectations?
Well, I think because the academy is going to continue for 9 or 10 more weeks, I don't know that he was necessarily good to go. I think that the academy builds on firefighter 1 and firefighter 2 in the manner that he was struggling. For example, actually combining all those skills as demonstrated in the live practicals. And
so there's no live practicals for firefighter 1 or firefighter 2.
I think you're getting into them in firefighter 2, as you can see.
Right, because that's how they know
correct.
He has the problem under stress, but he passed firefighter 2, notwithstanding his problems with stress, or the alleged problems with stress. I guess I'm really just asking you 2 questions. Just common sense. I give performance reviews all the time. It's not my custom to say, good news, you're meeting all the expectations, and now you're fired because you failed to meet my expectations. It just seems like a bizarre HR practice. But I guess the real question is, what is there in the record that would explain why this makes sense? And in particular, is there something in the record that says how often this happens? Is this a customary thing? Someone is certified as meeting expectations through firefighter 1 and firefighter 2, but then pushed out one way or the other before training is over? Does it happen all the time? Oh, sure, this constant. This is just the way we run our program. Does it happen occasionally, or is this the first time it's ever happened?
I don't think there's any evidence in the record.
Can I draw an inference from that? Because again, just as a matter of common sense, if in fact it happens regularly, I do not understand why that's not in the record. It's the key question in this case. Like, how does this make sense that you can pass level 2, but still not be meeting expectations? And if the answer is, I know it seems a little weird, Judge, you're not an HR expert, this does make sense, and here are all the times we've done this before, why isn't it in the record?
Yes, I don't think it was presented in the record. I don't think that the record presented anything related to the composition of this class in terms of how many passed, except for those discrete memos that showed some of the other performance issues.
Well, as a follow-up to Judge Harris's question, I mean, wouldn't it be very beneficial to the court to have the answer to this question? How common is it for recruits who achieve all the objective certifications but still be terminated or resign? You're telling us that there is no evidence of that fact, of that scenario in this record.
I cannot point to any evidence in this record about whether all of the other, well, the trainees that completed the fire academy would have successfully passed and become firefighters. Like, they would have successfully passed all the objective measures to become firefighters. That's true.
But the question is, they completed all the objective certifications, but they still were terminated or asked to resign. In other words, that gives us, I guess, what it troubles me like it does Judge Harris. I think if we had that information, then we have kind of a graph that we can measure this thing against.
Correct. I don't think that exists, that in the record in that manner. I know that there was a younger trainee whose recommendation to be excused from the program is in the record because he was struggling with SCBA and Mays issues, but he subsequently resigned, as the district court noted. It is the training class in and of itself is small in the general respect. So I don't think there's any evidence in the record as to that type of statistical answers in terms of how many of those trainees are going to not be successful. It's every trainee, including Mr. Whitaker. Mr. Whitaker's age was known at the time he was given this spot in the training academy. The training academy gives out these spots with the hopes that each of those individuals is going to successfully complete the program and become firefighters. There isn't.
So can I ask you a question about that? So who does the hiring in this question? Who picked him for the training program, and is it the same people who pushed him out?
So the ultimate appointing authority and firing authority would have been Chief Butler, but as the Deputy Chief Smeltzer did discuss in his deposition, that it's more of a panel. It's a very large pool, it's 2,000 people, and then it starts being whittled down. And so the panel would ultimately have highly recommended or recommended Mr. Whitaker. There's no evidence in the record of which one he was at the time, but it would have been a panel of uniformed firefighters and some HR that would have been then sent through a recommendation up to the fire chief.
Okay. So HR is involved with the hiring, but not with the decision here to terminate him from the program.
No, the decision for the firing would have been the recommendations of the training staff, again, up through the chain of command, yes, ultimately to the fire chief.
Can I ask you another question? Just something that concerned me a little bit about the district court approach to this case. So we have these comments by Captains Welsh and Merson, the Facebook page, and I track the district court's reasoning in saying these are not direct evidence. But that doesn't mean they drop out of the case. It's still circumstantial evidence that can be looked at when you do the McDonnell-Douglas kind of burden shifting regime and see whether there's a circumstantial case here. But the district court never comes back to them. And we have clarified probably even more since the district court ruling that that's a mistake. You actually have to come back to them and consider them when you're looking at the pretext question, the prima facie case, the pretext question. They go to the ultimate question in this case. What do I do about that? Do you have an argument for why that's not a problem in this case? Or?
Well, I think Captain Welsh's comment was not related at all to the termination. in terms, as the district court found, and I don't know that it's very probative when you look at it in relation to all of the contemporaneous documentation for the performance issues. As to the Facebook page, again, I don't know that that's really evidence of corporate culture related to the culture at the department. You know, as I already stated, Mr. Whitaker's age was known at the time he was given the spot in the academy.
Right, but by a different, if the hire and the fire are different, that doesn't really give rise to much of an inference of anything. And I am sort of struck by the fact that you have HR professionals on the hiring panel who, but not on the firing. You don't have the same hire and fire here, so it doesn't really matter.
Okay. Well, I would argue that even if it's not the same hiring and firing authority, that his age was known. The only thing that wasn't known was how he was going to perform in firefighting tasks. And so I don't think Captain Merson was saying that he couldn't do the job. In fact, he was just talking about, again, sort of the longevity of your career in relation to the pension. So there was no evidence in the record that the department was not keeping older firefighters or, you know, taking age into account. There was nothing in the record that showed that the department wasn't treating age neutrally, and I'm not sure that the Facebook post, you know, meets that test either. So, just a couple additional points. I do think that the record shows contemporaneous documentation that he was struggling, and that there were skills that he was continuing to, regardless of passing the objective matters measures, that he was struggling to complete even as he was progressing in the fire academy. Additionally, as Judge Floyd had mentioned, even if there is a prima facie case, once we shift the burden and it is shown that the department has legitimate decision-making reasons for the decision that was made, I don't think Mr. Whitaker can meet his burden for pretext. One, Mr. Whitaker's own self-assessment does not carry his entire burden. And additionally, he doesn't dispute that some of these instances occurred. He doesn't dispute failing the mace or the ladder the first or second time. He actually doesn't even dispute that he couldn't open the bail nozzle. He couldn't find the fire, that he couldn't get it to the right setting. And all of these are indicative of what is needed when you come out of the fire academy. As Captain Merson said in his deposition, it's imperative that a firefighter can find the fire. We're not talking about generalized office. Firefighting is hazardous. This academy is meant to prepare firefighters to go into the community, be in stressful situations, and rescue the citizens of Howard County. And I think that is important when looking at the pretext issue. Additionally, he has submitted evidence from the opinions of his fellow trainees. But here, fellow trainees are not even the same as ordinary coworkers. The trainees were in the academy just like Mr. Whitaker. They had no other knowledge. They, in fact, just offered generic comments like he was doing just as well as everyone else. Where in contrast, you have the trained evaluators. Their whole job is to make sure that individuals are meeting the task and able to become firefighters.
So can I ask you about this is just another sort of slight concern I had about this case. You are right, of course, that our law says the fact that a bunch of your colleagues think you're great just doesn't account for much, and the district court said that. But there were places where the fellow trainees were not just offering an opinion, where they were making factual assertions that were contrary to some of what the employer was saying. And I'm remembering there's one where there's this defiance issue that Sanchez raises, and the trainee who was allegedly defied says, well, that actually didn't happen. So I think there are cases where you are supposed to look at not the opinions of your colleagues, but when they testify as to a factual matter, that can create a genuine dispute. And I am worried that we are painting with too broad a brush here when we say it really doesn't matter what the colleagues think.
I think that most of his colleagues says that they did not recall or did not witness him being insubordinate, but I'm not sure that they would have been I don't know that that's enough, the conclusory opinions to just say that they're not sure. And I believe that one of the trainees, Udeka, I believe, did say that he witnessed Mr. Whitaker pushing back. He didn't call it insubordination in his deposition, that's true, but he said he did witness him pushing back.
Okay, but so just to be, we agree though that when a fellow employee testifies as to a fact and not, either this happened or it didn't happen, this happened that way, it happened that way, that's relevant. What is less relevant, minimally relevant, if at all, is just their assessment that we thought this guy was pretty good. And but if they are saying like, I was there, it didn't happen that way, that is something that should be looked at.
Yes, I agree.
Okay.
That's what the law says, correct.
Okay.
Additionally, when looking at pretext, one of the factors that the court can look at is whether the sort of consistency of the reasons that were offered. And I know that appellant says that certain issues were not raised, but I would disagree. In fact, one of the counseling forms does note that he had behavioral, one of the boxes checked was behavioral. That was the April 18th counseling form. And I do think that the memos are fairly consistent that his poor attitude and some of the stress-related issues he was having carried through his performance at the department. If the court has no further questions, I would just say thank you and ask to affirm.
Thank you very much. And Mr. Shaw, you have some rebuttal time.
Mr. Shaw, this is a summary judgment. There's no magic number, but could you just tell us 1, 2, 3, what are the material facts that are in dispute in this case? Just 1, 2, 3, or just one, or just two, or just three?
Yes, Your Honor. So the first material fact that is in dispute is whether, in fact, Mr. Whitaker underperformed at training. There's conflicting evidence in the record, for example, as to whether he failed a maze, or if he did fail a maze, whether that was indicative of poor performance. And I will elaborate just a little further on that one. There's testimony from the county by its corporate designee that it was common to fail mazes. There also does seem to be evidence that on the first attempt at one given maze, Mr. Whitaker didn't pass it, and then he rectified that and did pass it. That's just an example of one factual dispute. There's also factual disputes about the extent to which he had difficulty with ladders, the extent to which he had difficulty with nozzles. So that's one area that's very much in factual dispute, and in fact, in the appendix at pages 30 to 35, the district court spent 5 or 6 pages of its opinion sifting through all of these facts, and then ultimately drew inferences apparently in favor of the county rather than letting a jury look at those same facts and decide whether it goes one way or the other.
Well, let me ask you just, and then I'll let you continue to answer Judge Floyd's. But I mean, in some of these things, he's acknowledged that he had issues, like the nozzle incident. I don't think that there's a dispute regarding that, because he acknowledge that he had issues with the nozzle, removing the nozzle?
Yes, Judge Benjamin, he did acknowledge, like for several of these issues, the nozzle being one, the maze being another, that there were occasional issues that happened, but we have to look at the record. For one thing, he wasn't always counseled on those issues, so the county has a formal process by which they give feedback. And then the other issue is, were other trainees having those same issues? I mean, this is a training environment, so it's expected that trainees, and the county's designee testified that in a training environment, sometimes the trainee is going to miss the mark. So again, that's an area, I believe, where the jury could look at the conflicting evidence and decide that the reason that was given, that Mr. Whitaker had poor performance or couldn't perform well under stress, was merely a pretext for getting him out of the department because he was older than all the other trainees in his class. To Judge Floyd's question, yes, there's other areas where there are factual disputes, and the big one here, I think, is going to Ms. Purdy's question about the record. If we look at the internal memoranda that were given around the time or just prior to Mr. Whitaker's termination, those are internal memoranda from one trainer up the chain of command, but not given to Mr. Whitaker. So if we look at the April 16th memorandum and April 17th memorandums at 1146 and 1147 of the appendix, those are internal memoranda. And one of them does, I believe, actually say, not that Mr. Whitaker was insubordinate, but that at 1146, the trainer says, the action of not being able to navigate through the maze is not my concern. So he's not concerned about the maze. But he says the behavior that the trainee demonstrates when under a little stress is a concern for me. Okay, so he's telling that to to up his chain of command, but there's no evidence in the record that Mr. Whitaker was told that Mr. Whitaker was told, we're concerned that you have, you're having difficulty with stress. That's on April 18th. 2 weeks later, approximately May 3rd, 2018, they certify him at firefighter level 1. So again, there's a huge glaring factual inconsistency here where the county is apparently in some circumstances without even Mr. Whitaker's knowledge talking about things that are going on with his performance, not giving him a chance to correct them as they did with other trainees. This is consistent with, the discussion in the briefs about Mr. Whitaker being placed on desk duty and being forbidden to take part in training when that didn't happen to other employees. So there's also a factual issue here regarding how he was treated vis-a-vis other employees and whether he was actually, whether there were actually contemporaneous records of these issues or whether those are simply post hoc rationalizations for the county's desire to get Mr. Whitaker out of the department. And I see that my time has expired. If the court has no further questions, I thank you for your time.
Great. Thank you very much. Thanks to both of you for scrambling to do this remotely. We appreciate it. We are sorry that we can't do our usual custom and come down and greet you personally, but we hope that we will have occasion to see you soon so we can do that. Thanks very much.
Thank you.
It looks like we are all set, so we can begin argument in our third and last case today, number 25-2003, Robinson versus NCAA. And Mr. Kilaru, we will start with you.
Thank you, Your Honor, and may it please the court, Rakesh Kilaru for the NCAA. An antitrust case requires antitrust proof. And in this case, the district court entered a mandatory preliminary injunction without requiring any. The plaintiffs in this case...
Could I ask you just to start with mootness, just so we sort of establish our jurisdiction going in? And I've read your brief on this. So as I understand this, the exception, or so-called exception for capable of repetition but evading review, it's sort of a categorical question whether the action that's being challenged, I guess the denial of eligibility here, is by reason of its inherently short duration for remedy, the kind of action that would likely forever evade review. So it does seem to me relevant that this precise action has been reviewed on appeal twice now. What do we do about that?
Your Honor, I think that the key distinction there is the way in which the cases are now being litigated, this case in particular, and whether the way in which the case is being litigated would evade appellate review. We were fortunate to get decisions in the Third and Seventh Circuit, but that was because the plaintiffs in those cases filed suit on a pretty timely basis when they thought there might be an eligibility issue. So I believe in those cases, the plaintiff filed in January or February. Plaintiffs filed their suit basically a day or two before the season started, which dramatically compressed the timetable for the issue to be capable of review and is going to defeat, we think, the court's jurisdiction to review the issue in this and every future case where things are filed so close to the time in which the season begins. And I think that it's relevant. Of course, go ahead.
I'm sorry, I'm just trying to get my hands around this. Is there a practical reason why we should expect plaintiffs to wait till the last minute?
Well, I think, Your Honor, this case sort of illustrates why the longer you wait, the less likely there is that there's going to be appellate review of a decision in your favor. I'm not accusing the plaintiffs of doing anything to
But what if the
manipulate your-
decision is against you? Then wouldn't you want time for appellate review? I'm just not understanding the incentive structure here that means that plaintiffs will always wait till the last minute.
Your Honor, I can just say descriptively, there are 50 to 60 of these cases in the courts right now, and what we have seen over the course of the last year is that the time in which the suit is filed has gotten closer and closer to the season, which has a few effects. First, the judges believe in the district court that there's more of an immediate emergency, and so issue a decision very quickly. And win or lose, I think from the plaintiff's perspective, if they don't win immediately, the appellate review process probably isn't going to give them much of what they want anyway, because even the most expedited appellate review process will probably not get you the ability to compete in much of the season. On the other hand, if you prevail, the most likely outcome, with, as we've seen here, is that there won't be time for the case to be up on appeal, so you'll effectively get the benefit of competing for the entire season, and then the case will potentially be moved. So I'm just saying that that's descriptively what's happening. But I also think that the way the doctrine is described doesn't require that it be categorically capable of escaping review. I think you have to look at it under the facts and circumstances of the case. And here I think we have a good example of how the case and the issue has evaded review. You know, we did have an injunction issued on August 20th. We tried to expedite the appeal. We've come to the court as quickly as we can, but now the season is over, and there's an argument that the case is moved as a result of that. We know this issue is recurring. I think the site we put across several different pages of our briefs shows that this is an issue that continues to recur in the courts again and again and again. So it's clearly capable of repetition. And I think the facts of this case show how it can very easily evade review, and how, you know, we might just find ourselves in the very same position at the start of the next season in the same court if more players are seeking eligibility. And just on that note, Your Honor, I think from our perspective as the NCA, the complaining party, we certainly think that the issue is evading review and is capable of repetition. But I think even if you look at it from the plaintiff's perspective, at least one of the named plaintiffs in this case is seeking a waiver to compete for another season. So there's every likelihood, I think, if that waiver continues, that request continues, that the judge would be in the position, the district judge would be in the position of potentially entering the same exact injunction again at the start of next year, and then we find ourselves in this position again.
Thank you.
I think turning to the merits, if I could, Your Honor, that an antitrust case does require some antitrust proof. And in this case, the district judge didn't require any of the plaintiffs on two of the most essential elements of an antitrust claim. And that's the relevant market and harm to competition. As Your Honors have seen, we've pressed in our arguments of brief that these rules are not commercial and thus outside the scope of the Sherman Act, and I'll return to that argument at the end if there's time. But I really do want to focus on this evidentiary issue because it's a really critical issue, and I think it's the one that the Third and Seventh Circuits have recently focused on, and correctly, on pretty much the exact same record that you have here. In an antitrust case, and this comes from Alston, the plaintiff is supposed to come forward with economic evidence of current market realities. I'm quoting from the Alston decision where the court said that an antitrust decision requires a careful assessment of market realities. There is no question that the market in this case, the potential markets in this case, have changed. You have the House antitrust settlement from a year and a half ago. You have new payments being made to student athletes consistent with that settlement. You have NIL opportunities being available to student athletes. All of this has happened since the Alston decision. And yet there is literally no evidence in the record in this case of what is happening with those market conditions and what they mean for the relevant market. And a concrete example of why that matters comes from the named plaintiffs. The plaintiffs in this case, and I believe this is actually the opening of their brief, say that they were considering going to the NFL until they thought that they might be able to get an additional season of college. That is, in economic terms, a potential argument about substitution between collegiate and professional athletics. But there's no evidence in the record here of what the market is. And I think if you look at the record evidence here, you would see something that I don't think would pass muster in pretty much any antitrust case. There's a decision from Judge Floyd, I'm sorry.
I'm sorry,
Mike, you asked me a question?
I was muted, I'm sorry.
No problem.
Let me ask you about this. It looked to me like the judge did a quick look as opposed to rule of reason or a more in-depth market analysis, we're talking big money here now. It doesn't matter whether we're talking about Division I, Division II, Division III, JUCO. I mean, just Division I, it seemed to me to require a more than a quick look, and that the rule of reason should be applied in these cases. What's your position about that?
We agree, Your Honor. We think that's another error that we found in the district court's opinion, and we mentioned this in our opening brief. There is a reference in the district court's opinion to evaluating the restraints at issue here, quote, in the twinkling of an eye, which, as Your Honor, I think notes, is the traditional way that the quick look is described as opposed to the full rule of reason. And it is clear from the Alston decision that the rule of reason is how antitrust analysis is supposed to go forward here. And that's why I started where I started, which is the first step is looking at economic conditions in the relevant market. As Your Honor noted, those economic conditions are quite different than they were even from the Alston decision. But I think what was put in the record in this case was a textbook chapter from years before Alston, a Federal Reserve paper from years before Alston, the Alston decision itself, and then an expert report from a different case that just cited Alston as proof of the relevant market, and is the exact expert report that the Third Circuit recently concluded was insufficient to support the antitrust claim as to the relevant market in Elad. It's literally the same report. It was Dr. Maxey's report in the Elad case. So that's the report that was offered here. And that is the sum total of record evidence on the relevant market. There is no evidence on how compensation is playing out in college sports today. There's no evidence of substitution between junior colleges and Division I schools. No evidence of economic conditions in Division I sports and other athletic offerings. And as I mentioned, there's some evidence in this record that would complicate the view that college sports is a distinct market from other markets. So I think on the market issue, there's a glaring evidentiary flaw. But there's a separate flaw when it comes to the second antitrust element of harm to competition. It's a fundamental antitrust principle that courts have to look for evidence of harm to competition and not to individual competitors. Here, there's no question, I think, that the individual plaintiffs who sued believe they're being harmed, but that's not enough under the antitrust laws. A plaintiff coming in an antitrust case has to show harm to the competitive process. So what do you look for? You look for reduced output in the claimed market. You look for some wage effect in the claimed market, evidence that the restraint is operating to lower wages. And once again, there's no evidence at all on that issue in this record. There's no evidence of wages being suppressed. In fact, a wage suppression theory doesn't really even make sense anymore because under the House settlement, there is a cap on the spending schools can provide to players. So there wouldn't be increased compensation no matter who comes into the labor pool. It's the same amount of money, it just gets divided among different players. And there's a decision from the Sixth Circuit, the NHL Players Association case, and I can provide a cite for that in rebuttal if helpful, that essentially says you don't look at quality of individual players when you're looking at a market-wide assessment. What you look at is the market as a whole and whether there's some effect in the market. And then in terms of output, there's the same number of spots in Division I football regardless of who competes. So there's not an increase in output in the number of available spots if these students are allowed to compete versus they're not. It's just a displacement. Instead of high schoolers or underclassmen taking those spots, you have more experienced senior players taking those spots. So those are...
Can I ask you a question? I understood at least one of the theories to be floating around here to be, I think what's known as a group boycott kind of a theory. Like what the Division I schools are doing is penalizing workers, basically, if they first work for a competitor. And that you do that to sort of consolidate your market position vis-a-vis the competitor. So basically, we're competing with these junior colleges, and if we penalize people for having first played at a junior college, we can squeeze them out. Why does that not work, at least kind of as a matter of common sense?
There's, I think, a couple different reasons why that doesn't work, Your Honor. The first is that a group boycott claim wasn't pleaded here, so it's not in the case. That's a specific type of antitrust claim. It wasn't pleaded or pressed here. Even if you get beyond that, there's an evidentiary problem. even when someone asserts a group boycott, they still have to show some kind of effect in the market that's being created by the group boycott. What you typically would look for is evidence that because you are boycotting a certain type of laborer, you're able to suppress wages or reduce output. It comes back to that same point. This is actually a colloquy that occurred, I believe I had it with Judge Hermendorfer in the Pavia case, and she mentioned it in her concurrence in that case. But there still needs to be some economic evidence of a wage effect or of an output effect, even when you're alleging a group boycott theory, which hasn't been alleged here. And there isn't any record evidence of that. There are assertions that junior college players would make more money in college sports if they were allowed to compete, but there's no evidence that that would actually happen. And what we know about facts in the real world suggests that theory is wrong, because there is a finite amount of money that teams have to spend on players. And so it's just a question of who gets that money, not the question of whether more money would be available if older players were allowed to compete in the labor pool. And then from an output perspective, there's the same number of players competing in college sports, regardless of whether these students are allowed to compete or not. It's just an allocation of who gets to be in or who gets to be out. So we don't think the theory is pleaded, but even if it was pleaded, we don't think there's evidence to support it. I think the last thing to just note here, Your Honor, before I think saving time for rebuttal unless there's further questions, is that decisions like the one below do effectively bring the courts into this role of actively supervising pretty much every potential eligibility decision that the NCAA could make. This is something that was raised in Judge Thapar's concurrence in the Pavia decision. Should the GPA rule be 2.8 or not? I think even if you look at the footnotes in the district court decision, in this case, there is a question as to whether an academic eligibility rule, a rule that says there has to be a GPA requirement, whether that would be permissible. Setting aside the commercial argument, which we stand by, but I think if your honors are not willing to accept that argument, at least the rule needs to be the rule of reason applies to all of these rules. So that invites a huge amount of judicial superintendents, but it also then would require evidence. And so what we would suggest and submit, Your Honor, is it's similar to what the Third and Seventh Circuits have ruled. If you're coming forward and bringing an antitrust claim under the rule of reason to challenge NCAA eligibility rules, you need to come forward with antitrust evidence of harm to competition and of what the relevant market should be.
Counsel, I completely understand your argument. I mean, we are up on a preliminary injunction, right? So I think we have to draw a line here. You need something, you need some evidence, but you obviously, I think you would agree, but tell me if I'm wrong, you don't need what you would need like in an antitrust trial where you'd have like a whole bunch of witnesses and like, I don't know, a lot of statistical evidence and so forth. So I guess my concern about your argument would be, I don't want to write an opinion that makes it impossible for anyone ever again to prevail on a preliminary injunction if they can't show everything they're going to need to show to prevail. So what are we talking about here?
I think the easiest way to write that opinion, Your Honor, would respectfully be to do what the Third and Seventh Circuits did, which is say you can't have nothing. I know that doesn't answer the question of what the something would be, but I do think that if you look at the record here, there's clearly nothing. There's not even an expert report submitted in this case or any economic analysis submitted in this case. And so that should be, I think, a complete answer here. The question of how much evidence one needs to establish a likelihood of success in a preliminary injunction proceeding is obviously a thorny one that I know the court's grappling with in a number of other cases. I think in an antitrust case, I wouldn't purport to suggest that the court suggests some bright line rule, but I think there needs to be some attempt at an economic analysis of what's actually going on in the relevant market, as opposed to just a citation to cases from years ago that did not address current market conditions. And there are many ways in which that evidence could be assembled. I would note that one way in which it could be assembled is to file the lawsuit earlier and seek discovery over the months that could be had. I mean, in this case, for example, the plaintiffs knew that they might be deemed ineligible as early as February of 2025. The lawsuit wasn't filed until August of 2025. But if the lawsuit's filed in February, a plaintiff can ask the court to proceed over expedited discovery, get evidence of what's going on in the current market, get evidence of what's going on from a compensation perspective, and try to put together something that would be sufficient evidence for preliminary injunction. What I don't think the law allows is to come forward with pretty much nothing and say that because it's a PI posture, that nothing is enough. If there are no further questions, Your Honor, I'd ask for a rebuttal for 3 minutes, but thank you very much.
Okay, and then Mr. Gianola, hear from you.
Yes, Your Honor. John Ginola for the plaintiff appellees, and may it please the court. Maybe not briefly, but I would like to address mootness. First, we believe that this matter before this court is moot. We don't think there's a live case or controversy. The preliminary injunction was directed solely to these players, to this season. It does not apply. The season is over. Obviously, we cannot go back in time and undo any mistakes. We don't think it's capable of repetition either. The court was...
Let me ask you about that, because I think it's interesting that one of the players is already filed for a waiver as to the same issues as in this case. So what's your best argument that it's not capable of repetition?
I will confess I was not involved in his filing of another waiver, so I have not seen it. My understanding is that that player was injured this year, so I assume that his waiver actually has to do with the red shirt rules and not with the JUCO rules that this case applied to. I'm happy to be corrected by the NCAA's counsel if they know differently, but I do not believe that there is a separate waiver that is actually, or at least I don't have any reason to believe that there's a separate waiver addressing these exact issues, because I think that would go to an injury or red shirt of some variety and not what we have litigated here before. Some of these plaintiffs did have red shirt waivers, but that was not an issue in this case.
But I think if you look at the years and if we look at the years that they, I guess, were the JUCO, there is a possibility that they could still make the same argument regarding the years of eligibility, the seasons and the years of eligibility, at least 2 or 3 of them.
I think that they could raise that. I agree with you. I don't know that we have. I think that that would be possible. I don't know that it would be foreclosed. It has not been made yet, though, and it is certainly not a part of this injunction. I think to do that, they would have to go back to the district court and get some other kind of order, and presumably that would involve another hearing and another set and another evaluation by that court. I think the Sixth Circuit addressed this in its Pavia decision. Finding that moot is, I think I don't litigate in the Circuit Court of Appeals often, but I think the case or controversy before us here is this specific preliminary injunction. So I agree with Your Honor that they could do that. I don't know that that would keep this alive, because I think that would be a different order related to different people and have different findings.
Well, let me, in this case, this Mr. Edwards has been playing football since 2019, and 2 or 3 years of it was JUCO. So don't you think it's about time that these cases, when you exceed 5 years playing football, that maybe we all decide whether it is a Sherman antitrust problem with the NCAA? How can you say this case is moot when this guy's played since 2019 and 3 of those years were JUCO?
Yes, Your Honor. I think these cases presented a unique fact pattern because, A, the NCAA issued a waiver in December of 2024 related to Mr. Pavia. That decision set into motion a whole lot of decisions on these clients to withdraw from the NFL. And then on top of that, in June of 2025, you had the House settlement, which sort of reconfigured college sports and certainly sort of changed a lot of these dynamics. So I personally agree with Your Honor that even these players have been around for a long time. This is a sort of unique set of facts that was kicked off by this waiver from the NCAA and then compounded by this House settlement. I would hope that those would sort of shake out in maybe this litigation and many of the other pending litigations. But this particular injunction was only for these players in these years, and I don't know that keeping this alive or ruling on it will affect any of those litigations. So we do not think it's capable of repetition. We also don't think that it's the same complaining party could find itself in this, despite Judge Benjamin's questions. We don't think that the same complaining parties would find themselves in this, and that's a vital question under this theory. The sort of seminal case everyone cites to, Spencer v. Kinma by the U.S. Supreme Court, says that. The interestingly named Fourth Circuit case, Stop Reckless Economic Instability versus the FEC, the Pavia case in the Sixth Circuit, all of those seem to point out that the same parties have to face this. We do not think these same parties will face these particular set of issues, certainly not under this injunction. And finally, we don't think the rule of restitution is in front of this court, so we don't think that that's something to be discussed. Moving on to substance, I would like... My apologies. I thought there might have been a question. Moving on to substance, I want to point out and tag along with something Judge Harris said. This is not a fully litigated case. This is not a fully litigated antitrust case. This is a preliminary injunction. The questions are whether my clients were likely to succeed, whether they're likely to suffer irreparable harm, what the balance of the equities, and whether the injunction was in the public interest. To a certain level, I do not disagree with Mr. Kalaru. I think all of that evidence is certainly vital in an antitrust case. The cases he's pointing to, though, I think the NHL case he cited took 8 years to decide. That type of evidence takes a very, very long time to develop, and it is not possible and not practical to sort of require it on the front end on a preliminary injunction. So I think that's where we differentiate. If this were the end, if this were a decision on the merits, I do not disagree that that is the type of thing that we would need. But the idea...
Well, let me ask you this, but don't you, I mean, the issue that appears to be here is that you have to, I understand that we're at the preliminary injunction stage, but you have to have some evidence, and it seems as if the district court relied on this Maxey report, Dr. Maxey report, and even in the Third Circuit, I mean, they said that it was insufficient. So, I mean, you have to have something, right?
Yes, Your Honor, you have to have something. I will agree it is not the world's most robust evidentiary case. We have a learned treatise. That is evidence. We have here a report, which is admittedly hearsay, by Dr. Maxey. Those are, we also have all of these other cases, and I understand those are not evidence, but they are indicia of our likelihood of success. So we have a scintilla, we have a little bit of evidence, we have enough to hang our hat on, we have then multiple indicia. We have all of these court cases acknowledging that there is a market. We have the House settlement in June, where the NCAA agreed that there was a commercial market for athletics as part of that settlement. Now, I'm not saying that that's some sort of race judicata over here that they have, forsworn any argument against a market, but those are all indicia of our likelihood of success of proving that there is a market. The court invited, the district court invited the district court invited the NCAA to opine on what the definition of a market should be, to explain how to do it. They declined to do it. They said they could not do it. They needed an expert to do it. So the idea that they can now come back and say, oh, well, you've not defined this market. You didn't have evidence. We agree the evidence is light, but the indicia that we are likely to succeed on that, I believe, is pretty strong. And so that is why we think that we have met that hurdle. I don't know that that would be enough at the end, but certainly at this stage, when things are pressing, especially given, I want to address the idea that we could have brought this complaint months earlier. The House decision did not come out until, I think, June 5th maybe of this year, that completely rewired college sports. It completely rewired the antitrust analysis, because now with that settlement, there is revenue sharing. There are limits, as Mr. Kalaru pointed out. So the idea that we could have done all of this sooner is just not really practical. One of the plaintiffs did not even get his waiver. So on a quick level how this worked, our clients went and applied through the NCAA's internal system to seek a waiver for this year. And their basis for that waiver was, look, we think you made a mistake. When you granted this Pavia waiver in December, you applied it to seasons and only, and not to years for the calendar. So they were trying to comply with the NCAA's internal procedures. Those took, they take months. The NCAA looks at those. So it is not that we forswore or we waited on purpose to do this. As Judge Harris pointed out, there are severe downsides to waiting until the beginning of the season to file these. In fact, one of our plaintiffs suffered him. He could not play. I think all of the clients missed several weeks of practice. One of them couldn't play any games because he had some other delays in getting practice. So there was no delay on the plaintiff side. It was just trying to grapple with this constantly changing landscape in college sports. So we think that yes.
Counsel, can I just ask you a question? Putting to one side sort of the evidentiary support question, I couldn't figure out from the district court's opinion what theory of anti-competitive effect or harm it was adopting, just as a matter of logic. Like, what did it think was the problem here? Can you just tell me sort of what is your theory of why there is an anti-competitive harm as a result of counting junior college years toward your total years playing?
Yes. With regard to that specific effect, we think that...
Well, isn't that what you're challenging? Did I ask the question wrong? I thought that was the challenge in this case. You ought not count the years spent playing in junior college toward your total years playing. Is that not the question?
It is the question. We would put a lot of nuance having read all, but that is the basic question. We would say that the NCAA has a monopsony power in the market on these. It is placing artificial and arbitrary restraints on these athletes, especially with regard to JUCO. We say JUCO, there's actually another league as well, NAIA. It is putting arbitrary restraints on those. And it is artificially depressing the labor market. It has used that to lower overall compensation to athletes.
Okay, so that's your theory. It's not about competition with junior colleges for labor. That's not your theory.
If the junior colleges would join me in this case, I would greatly appreciate it, but I don't know that my clients have standing to assert a theory like that on behalf of the junior colleges.
Okay, so this is very helpful to me because I think the district court was talking about competition with junior colleges, but you're not interested in that. The thing you are defending are the allusions to the idea that there might be wage depression in this market.
Yeah, and let me clarify. I think there is some competition. Okay, this is the issue with this. The NCAA has a monopoly in broadcasting. Oh, sorry, I'm not supposed to move my hands. The NCAA has a monopoly in broadcasting and exhibiting college sports. It has a monopsony in acquiring college athletes. To the extent it does compete with junior college on both of those fronts, it does sort of compete with the junior college in acquiring athletes. So I think that these restrictions, so we in some regard, we also have a theory that by placing these restrictions on these athletes, it is discouraging them from attending junior college and encouraging them to attend the NCAA. So there are, I guess, two theories. One is they are artificially...
And what is the anti-competitive harm from bringing more players into Division I?
Well, I think that sort of goes to the harm to JUCO, not necessarily...
Right, which you are not standing on.
Right.
Okay, all right, so let's forget that. Okay.
Okay.
So the one theory in this case is wage depression in the market. And the theory there just like explain it to someone who's not a huge football fan, but the basic idea, as I understand it, is you're excluding people with more years of experience. They would be better. They would therefore be able to sort of generate bidding wars for their better talent. And because this is an atypical market, that would actually, having more people in it would drive up the wages rather than drive them down. Is that the idea?
I am not an economist, but I believe so, Your Honor. And I will just say, as a sort of lunch pail litigator, it terrifies me to be limiting my case right at the preliminary injunction stage. But at this point, all we're talking about is they are instituting these JUCO penalties. They are doing so to manipulate the labor market, and we believe that they are doing so to lower overall compensation.
Okay. I just have a question about sort of the logic of the theory, and then I'll stop because I really struggling here. If that's the theory, it would apply to anyone who wants to play a fifth year, right? Whether or not, by limiting people to 4 years rather than 5, you'd have the exact same argument whether or not that 1 year had been spent at a junior college. And that's the argument that shows up in the Seventh Circuit case, right? That guy didn't play junior college. He just wanted to play a fifth year. And so that's the theory they ran. Well, if you let 5-year people in, that will actually push up wages because they'll be better and people will bid for these better players. There'll be wage competition that will benefit everyone. So I guess this sort of goes back to my very first question. If that's your theory of economic harm, why is this a case about junior college years rather than just a case about you shouldn't be able to limit people to 4 years?
Well, in our case, I think the distinction, and maybe it has been inartfully pled, but I've tried to sort of weave this throughout all of our briefs. We think the distinction in this case is that when the NCAA granted that blanket waiver following the Mr. Pavia decision, it implicitly admitted that it had no rational basis for preventing those junior college players from playing. That waiver.
Oh, so you're saying that once you shift the burden, they might have some like really good reason to only let people play 4 years in Division I, but not a good reason. Oh, okay, so there might be different justifications for they would have the same anti-competitive effect, but one would be easier to justify than the other?
I do think so, Your Honor, and I think that's why this slippery slope, I think it was Mr. Kalaru referenced, I think that came up during the arguments in the Sixth Circuit in the Pavia case. Well, what about GPA? What about this? I have not studied it, but I presume that the NCAA would have very good reasons to do that. I think the issue here and why all of this gets kicked off by this Pavia waiver is because when they made that waiver, they said your seasons playing in junior college do not apply, but your years attending school do apply. And there's never been a reason, and I don't think they can offer a reason for why they should make that differentiation other than there's just simply trying to keep people out. I think if you look, my guess is they have very good reasons for almost all of their rules. I think that waiver, though, was so fundamentally bizarre to say that a season playing this sport doesn't count towards your eligibility of playing the sport, but attending school in a non-NCAA institution does count, is just so fundamentally inexplicable for any reason that would differentiate us from those other rules.
Well, I've sat here and listened to I don't know how many minutes of argument about all the things that are wrong, etc. And then you come in here and argue that this case is moot. My concern is we have a substantial portion of 2 of the 5 power conferences in this circuit. And I just don't particularly want these people running into some district judge and getting an injunction without some guidance from this court. I don't care what the outcome is, it's just a matter of getting the issues resolved. Apparently you want it both ways.
Well, Your Honor, I think it's moot. I do think that, but if you don't disagree, I'm going to argue, I'm going to present the substance. The issue is, finding the preliminary injunction moot does not mean it's not going to be litigated below. I think in the Gloucester County School Board case, and I of course don't want to explain this court's opinions to itself, but I think this court provided a very good explanation to the district courts on how to apply and how to find for preliminary injunctions. So I think that roadmap exists. I think in this case, we have a unique factual pattern that's not going to repeat. And so that's why I think it's moot. So I don't know that we need more guidance to the district court. I don't think I would ever say more guidance is bad. I just think that the case is moot and we can follow Gloucester County pretty well. And I think we did in this case.
Okay, well, thank you very much. And then we have a few minutes of rebuttal time.
Thank you very much, Your Honors. On the mootness issue, I would just note to start the scope of the injunction that was issued in this case. It's quite broad. The judge precluded us from applying, quote, any NCAA eligibility rule that would preclude the plaintiffs from engaging in intercollegiate competition. It was limited to last season, but I think when you say any eligibility rule, it would fold in the issues that we may have with Mr. Edwards coming into next year. In terms of the injunction,
Let me ask you this. So he says this case is similar to Pavia, but the eligibility issues were different in that case. Is that correct?
Your Honor, I think the answer is yes to that question in a couple ways. So the underlying theory was the same. Mr. Pavia was saying his junior college year shouldn't count. So in that sense, it's the same. But the issue is different because in that case, the NCAA granted a waiver that allowed all of the students to play for the rest of the year. And so the court said, well, you have given a waiver that takes this issue off the table, so nothing we do is going to change the outcome. There wasn't a waiver given in this case, so actually that's the key distinguishing factor for Pavia.
I thought the district court said you can't apply any, immediately grant them waivers of any NCAA eligibility rule that would preclude them from engaging in sports based on their time spent at a junior college. I thought this was very junior college specific, which sort of goes to the question I had for your colleague about some of the theories here seem to go well beyond whether you spend time at a junior college or not.
Your Honor, I think the issue is that no matter how you come into a new eligibility issue next year, it's going to bottom out on the question of whether the junior college issue counts. Okay. So that's really why it's not moot. To answer your question, Your Honor, I think the problem we have here is really an injunction that's in search of a theory and in search of evidence. It's not clear, to Your Honor's point, from the decision itself what actual antitrust theory the judge was offering. I think that's in part because the judge applied the quick look. To Judge Floyd's question earlier, if you look at JA 1135, the court said it's comfortable on the record at this juncture concluding in the twinkling of an eye that the challenged rules are restraints on trade. That's applying the wrong legal standard, so that alone is a basis for rejecting the claim. But if you get past the quick look issue and go to the theory that my colleague mentioned in his argument, you still need some proof of the relevant market and you need proof of the theory of competitive harm. As to the relevant market, there's nothing in this record that could be based on. The Elad decision, as Judge Benjamin noted, the report has already been conclusively rejected. There's nothing beyond that. And then on the theory of harm, I would just look to the Sixth Circuit's opinion in NHLPA, which is, if I could finish, 325 F3rd at 720. And it says that shifting the quality of players in a market isn't an anti-competitive harm. You need to show something more, and that's what was absent here.
Can I ask you just a quick question about the Seventh Circuit opinion, and I can't pronounce the name, but...
I think it's Forkerin, but it took me a while to get there.
Okay, in that case, I thought that court also rejected this theory of the wage suppression theory. The dissent advanced it, and the majority said there's just literally no evidence in the record. And I guess I have not gone back to look at the record in that case, but I wondered if you had any views about whether the record in this case is substantially better, or whether if we were to endorse that theory, we would be splitting with the Seventh Circuit.
I think it would create a circuit split, Your Honor. The record is a little different in that you have the Maxey report here and you didn't have it in Forkerin, but I think the Maxey report was really submitted in a different case, so whether it's even admissible here is a different question. But the logic of the Seventh Circuit's opinion applies with full force here. I think there the court noted, it typically doesn't make sense to say when you have more laborers in a market that that's a problem for wage suppression. It typically goes the other way. So you should need some evidence that suggests it's going in the other direction, and that's the evidence that's absent here. If there are no further questions, Your Honor, we'd ask that the judgment will be reversed, and we thank you very much for your time.
Great. Thanks to both of you. We appreciate you arranging to be here remotely. We are sorry we cannot come down and greet you personally, as is our custom, but we do hope that we will see you both soon and have an opportunity to do that. And I guess we will ask that our remote court be adjourned for the day.
Thanks very much.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.